Hi everybody, welcome to Perspectives on Alibis and Corroborators, Core 133 here at Flagler College. So this course is going to be a little bit different than a lot of courses that you guys have taken because unlike a course on content in Alibis and Corroborators, despite the name, this is a course to teach you how to think like a social scientist using alibis and corroborators as the kind of topic area to explore how we study a certain topic as social scientists. Because this is a course on how to think like a social scientist, we can't just dive in talking about alibis and how social scientists discuss and study alibis. We have to zoom out and view the entire field of legal psychology, right? Or psychology and law, forensic psychology, a bunch of different names that we can call that. So what is legal psychology? Legal psychology is really any application of psychological research methods, theory, and or practice to a task faced by the legal system. So basically taking what we know in psychology and just applying it to the legal system. I'll talk about that a little bit more in detail in a couple slides, but generally, like I've already mentioned, this has several names. Forensic psychology, psychology and law, legal psychology, psycholegal research. There's a bunch of different names we can call this, but we're basically taking what we know about the human mind, the human psyche, and applying it to the legal field. So how is psychology relevant to law? Well, there's a bunch of different ways that we can see where psychology is related to law. Number one, it could be the motivation. For example, what caused the behavior of the criminal. That could be what caused the criminal to commit the crime. That could be what caused the criminal to act a certain way after the crime or before the crime. But motivation is something that's very interesting, or that psychologists are very interested in. Persuasion is also one of those things. And persuasion is not limited to just psychology, communication, journalism, marketing. There's a lot of different fields that study persuasion, but psychology might look at persuasion and apply it to the legal system by looking at ways that lawyers and witnesses might attempt to influence a judge or a jury in deliberations, or in deliberations like with a jury, an attempt to persuade each other, right? And so persuasion can be very interesting. It could even be a suspect trying to persuade the police that they didn't commit a certain crime. What are some ways to be persuasive, and what are some ways that aren't quite as persuasive? There's also this idea of perceptual or cognitive processes. Psychologists are very, very interested in what we perceive, what's the threshold for perception versus overstimulation, how do we process information. So for example, how accurate are eyewitnesses? What affects the likelihood that an ID will be accurate, or even like the memory of an eyewitness? What affects your memory, that cognitive process of memory? What are certain things that might impair your cognitive process? For example, alcohol or drug use, being tired, being overstimulated. Do juries understand expert testimony? How well do people actually cognitively process certain information that's given to them? And then another area where psychology is relevant to law is in decision-making, right? How do people make decisions? And decision-making takes place throughout the whole criminal justice system, from how did the police decide to investigate a crime or to ignore it? How do prosecutors choose to prosecute? How does a defense attorney choose to argue their case? How does a jury choose to make a decision, right? So there's a lot of different areas where decision-making is also relevant. So where did psychology and law begin? It really had its beginnings in the late 1800s and early 1900s. Hugo Munsterberg wrote a book called On the Witness Stand in 1908 that set the foundation for what many consider to be modern-day kind of forensic psychology. He was not the sole researcher in this area, but this kind of text pushed for research in the legal area and made a very compelling argument that psychologists can apply their training to the legal arena. However, the legal system has always been somewhat hesitant to allow psychology or social scientists into the legal arena kind of broadly. Experimental psychology has reached a stage at which it seems natural and sound to give attention to its possible service for the practical needs of life. So, what Munsterberg is arguing here is, we're doing all this psychological research, but to what end? If we're not applying it to the practical needs of life, and that's every area, including the law, what good is the research that we're doing? And that's kind of the argument that's been kind of pushed. So there was a period of inactivity after Munsterberg got people all excited about it, where the legal community resisted and avoided incorporating psychological research into the court system. From the 30s to the 70s, people just kind of said, you know what, we probably shouldn't really be applying this. Let the law be the law. Let psychology be psychology. In the 70s, there was a resurgence of psycholegal research being done with a renewed emphasis on field studies, which helped establish the relevance for social psychology. What is it how do people act in groups? What we're seeing certain like jury groups or certain police subcultures forming, how can social psychology discuss those kinds of issues? So where are we today? Psychologists in almost every subdiscipline are examining legal issues. Cognitive psychologists study it, social psychologists study it, clinical and counseling psychologists study it. Division 41 of the APA, which I'm a member of, is the American Psychology and Law Society, and it is quite literally a division of APA that just focuses, it's an interdisciplinary division of APA that just focuses on psycholegal issues. And it's a very, very important, very active division within the American Psychological Association. So there are some issues in unifying psychology and law. And so this tension between the two isn't really surprising to people who understand it, right? Some of these issues are kind of even in form, right? Psychology is the scientific study of human behavior, right? I want to know why you did this or how you made that decision. Law doesn't really care about the why all that much, right? Law is more of an attempt to control human behavior. Don't do this, you need to do that, right? I don't care why you don't need to do it. I don't care why you need to do it. Just don't do it. However, historically, law and psychology also differ in a lot of methodology and values, which we're going to talk about. So in comparing and contrasting psychology and law, we can see that there's very, very significant differences between the two that does make it difficult for the two kind of fields to interact with each other. Psychology is inherently empirical, right? The world can best be understood through research according to psychology. Law is much more doctrinal, right? The world is best understood by precedent. We don't want the law constantly changing. We don't want the whims of one political party or one president or one legislature to change the law drastically, and so we rely on precedent to keep stability across the law. Psychology doesn't really care about that, right? If we find new research to find out something's bad, we need to stop doing it, right? At least according to the psychological framework. Psychology also deals with quantified maybes, right? It deals with probabilities. So more likely than not, if X is present, Y will happen. The law does not like that, right? The law wants absolutes. Did you do it or did you not do it? Are you sane or are you insane? Are you guilty or are you not guilty, right? We want to just say, yes, this is what it is, as opposed to these kind of more probabilistic ideas. And these probabilities can sometimes be somewhat problematic for people in the law. For example, if I said there's research to suggest that male expert witnesses are more believable in general than female expert witnesses, assuming all else is equal, showing this kind of male bias. That doesn't mean, though, that you should never hire a female expert, right? Because that gender difference is assuming all else is equal, right? If the female is more educated, if the female is the leading researcher in an area, she's going to be a better expert than a male who's not as educated or is not as much of an expert. And so there's this kind of probabilistic concept of, assuming all else is equal, but can we assume all else is equal? Oftentimes we can't, right? And so because of that, these probabilities can sometimes be a little frustrating for people who work in a more legal setting. Psychology, in much the same way, talks about what happens generally, whereas the law cares a lot more about what happens in a specific case, right? We don't care if 9 out of 10 mass shootings are committed by straight white men. Who committed the mass shooting in this case, right? That's all we care about if we're in the law. Psychology is very, very objective, right? Try and integrate all the findings into one refined view of the truth. One study in psychology is not enough to say, see, now we know what happened. No. We need the totality of the scientific view. We need the totality of the scientific evidence to look at and say, okay, all of these different studies taken together show us what kind of the truth is. The law is adversarial, right? The law is not trying to find the truth. They're trying to find a truth that you can prove or not, right? It's adversarial in the sense that attorneys represent one viewpoint. If I'm an attorney, am representing my client in the best interests of my client. I'm not trying to say, well, I think my client did it, so let me tell the court that. That's the opposite of what I'm trying to do in the law. Psychology also has more of a proactive orientation, whereas the law has a reactive orientation. Psychology might say, what if we allowed juries to do this? What if we changed the police policy to this thing? How would that possibly affect something? Whereas the law says, no, we can't play this what if game in the future. We can only act based on something that's happened. And so we need something to happen for us to actually function in the law. And so with all of these differences, which there are somewhat substantial differences between the two, it's sometimes very, very difficult for the two sides to communicate with each other, which causes a lot of that tension that's felt between psychology and the law. Some other criticisms that the legal system has of psychology is that there's a lack of ecological validity in psychological research. Ecological validity basically just means how real world is the research that we're doing. As we probably all know from, 8th grade science class when we learned the scientific method, we should control for as many things as we can in the scientific method in order to therefore say we know for a fact the independent variable is causing the change in the dependent variable. The reason why the legal system doesn't like that is because in order to control all of those variables, we end up fundamentally changing the situation that the legal system finds themselves in. If we say you're going to have the same judge, the same jury, the same attorneys, and all we're changing is the expert witness in this case, now we know the effect of that expert witness. The legal system responds and goes, yeah, that's great, but we have different judges, different attorneys, different moods of a judge on any different day, different sleep of the attorneys on any different day, and how rested they are before a trial or a hearing. And so all of those things make it to where your psychological research has strayed so far from what it is that we actually deal with on a daily basis that we're not even sure that we can apply your research to what we do. We also have the problem in psychology, according to the legal system, that we go beyond the data to make moral judgments. So, for example, we might say, we think this person is incompetent to stand trial because they don't really understand what they did was wrong. Well, can you point to exactly why you think this person's incompetent? Well, not really. After doing having a couple sessions with this person, we just kind of think that they're incompetent. Another problem is in this idea of moral judgments is sometimes psychologists will do research, and this is real research in the eyewitness field, that shows that child victims are re-victimized by having to testify in trials against their attackers, especially if it's sexual assault. So the psychological suggestion is we should do all of our interviews in court, all of our cross-examination and direct examination in trials through closed-circuit television so the child does not have to see their attacker in court because of that re-victimization that happens. Well, that's a moral judgment, right? Because the Constitution says you have the right to confront those who are accusing you, right? If I'm a defense attorney, it's not your job to try and protect the victim. It's your job to protect your client. So I'm going to fight like hell to make sure that child is in the courtroom, right? Because that's my job as a defense attorney in an adversarial system. Psychologists would say, whoa, don't do that. You're going to traumatize the child. The law and psychology, because they have these two different kind of value sets, then are at conflict with each other. There's also the idea of intruding upon legitimate activities of the legal system. Sometimes experts will try and persuade when their job is to perform. Sometimes during hearings, an expert might say, I think this is a bad eyewitness identification because of these factors, and therefore I think you should find them not guilty. Whoa, your job is to tell us the science. Your job isn't to tell us whether this person did it or not. You're going way beyond what you're supposed to be doing and intruding on these legitimate activities of the legal system. So can psychologists be successful in communicating research in court? Absolutely. In 2001, APLS, along with the APA, have published eyewitness guidelines that a lot of police departments have used and changed their eyewitness procedures because of the research that's been done in psychology. During Brown v. Board of Education, the famous Supreme Court case that ended segregation in our schools, APA wrote an amicus curiae brief, which is a friend of the court brief, examining the psychological consequences of segregation, and the Supreme Court said this brief was compelling, that the dangers of segregation are a lot more than just educational, they're psychological, and we need to consider that. And so psychologists can be successful in communicating research. However, these differing paradigms always will continue to be a problem just because we have such different goals and such different structures within our fields. So there's different ways to influence policy with social science research, right? For example, you could influence the legislature by lobbying. APA has lobbyists that work in Washington, D.C. and try and lobby our United States Congress about psychological issues. Some legislative congressmen and congresswomen will even place psychologists on their legislative staff to help understand the research that's being done and the issues that might be present in the field. Also, and this happens quite a bit, providing expert testimony at legislative hearings. Expert testimony isn't limited just to trials, but if Congress is debating a law, they might have a hearing in a committee to say what does the science say about this so we can pass the best law. There's also influencing the courts. And we've already talked about amicus curiae briefs very, very briefly. Obviously, by the way, because all these words are bold, you should probably know these for the exam. But amicus curiae briefs are arguments by a third party to the dispute that seek to inform the judges on matters relevant to the dispute. And these can take the form of several different things, but the basic idea here is I don't really have a dog in this specific issue, right? In Brown v. Board of Education, I don't have kids that are in segregated schools. I'm not trying to keep the schools segregated. I just want to, as a friend of the court, which is what amicus curiae means, friend of the court, I just want to say, FYI, here's some stuff you guys might want to consider. One of the ways that they can do this is in a science translation brief, which is intended to be an objective summary of the research to help kind of point justices in the right direction. Look, for years and years and years, we've been doing these eyewitness identification procedures where we really are doing a bad job for a variety of different reasons. Here's why these procedures are bad, and here are procedures that we've shown can possibly be better. And that might help point justices in a direction. Then there's advocacy briefs. These take a position on some sort of legal or public policy issue. It is the opinion of the APA that fill in the blank, right? That could be issues on women's health and abortion. That could be issues on race, on immigration, any sort of issue, but it's advocating for a particular side. Here's the situation. Here's our stance on this, right? There's also consulting, right? Sharing psychology with practitioners. This could be attorneys, this could be police chiefs. I personally do some of this work as a jury consultant outside of Flagler, where attorneys will call me up and say, I've got this case. I'm not really sure, if the jury is going to buy this argument, and I'll help go in and do a mock trial and say, let's find out if a jury buys this argument or not. Let's use social science to see if this is believable or not. Oftentimes during, I'll get hired even pre-suit to say, hey, this party came to us. They know that they've injured our client. We just want to find out how much is this case worth. Can we do a small mock trial to figure out what the average damage award is so we have some sort of way to negotiate instead of just pulling numbers out of the air? And so that's some ways that we can use our social science to also influence the law, and specifically can even influence trial strategies in court. So what are some of the topics studied in psychology and law? We study jury decision-making, forensic assessments, confessions and interrogations, eyewitness behavior, witness behavior in court, false guilty pleas, and even alibis and corroborators, which is the main purpose of this class, or at least the topic in which this class is going to be studied under. So as a general overview for this course, just so you're ready for what this course is going to look like in the future, this class explores the specific topic of alibis and corroborators, relying heavily on the scientific literature, as well as your textbook, Alibis and Corroborators, Psychological, Criminological, and Legal Perspectives, that Dr. Megan Kienzle and I edited together with Springer. This book that you're going to be using is the first and only book ever written on the topic of alibis and corroborators, so it's quite literally a state of the science on the topic. The course is going to challenge our beliefs about our criminal justice system that you very well may hold dear, right? There are certain ideas about our criminal justice system that they've always just kind of been that way, and therefore they always just should be that way. Hopefully, through the lens of alibis and corroborators and getting you to think like a social scientist, it'll cause you to critically evaluate our current policies and practices, while also helping you understand what it means to be a respectful and inclusive member of the community, which is, of course, one of our core values here at Flagler College. And so we're going to start at the beginning with how social scientists measure things, how social scientists study topics. Then we're going to dive into the first article ever written on alibis and see how the field of alibis and corroborators has grown from that very first topic ever, and see how do social scientists go about the decision-making framework to decide what to study in this topic. As always, if you have any questions, please feel free to let me know. I'm always available. Feel free to comment on this video if you have questions with timestamps on it about anything I said that you have specific questions about, and I'll try my best to answer those. Thank you all, and I'll talk to you soon.